Buenas tardes de nuevo.
Good afternoon. Welcome back this afternoon. We're continuing with this really interesting conference. And to begin the afternoon, we are going to listen to another piece of music from Jimena, Suite Number 3 by Bach. Thank you very much.
Hola, buenas tardes.
Good afternoon. My name is Isabel Jiménez Garcia. I'm a judge in Barcelona in the Mercantile Court, and I'm here to stand in for Lucia Aviles, who unfortunately couldn't come here, so I'm doing her job. Thank you, Lucia, Gloria, and AMGAE, for giving me this opportunity to take this very privileged role. I would like to say thank you to the speakers coming to participate in this conference. This is a diverse and ambitious round table to talk about gender perspective. We're going to be talking about children, family. We're going to travel through different territories such as Libya, Netherlands, going to Tunisia, France, Germany, and Italy. Each of them are going to talk about the challenges faced by women in these different countries, taking into account their cultural diversity. So the protagonists here are the speakers, so I shall give them the floor. Of course, we have Gonzalo Alcoba as our rapporteur, but first of all, our colleague from Libya, Fatma Chenaib, she is the Deputy Chair of the Administrative Council of the Judicial Power in Libya. She's going to talk about family matters in her country. Thank you. Dear sisters and brothers, I have the pleasure to be able to speak to all of you here today, because Libya, well, it's the first time that Libya has been able to attend a conference with women judges, because normally it's the men who are representing our country's judicial system. We're going to talk about the civil code in Libya and the rights of women according to the family code. If we talk about the civil code, family and women in Libya, if we take into account the constitution in Libya, we know that it has been suspended since 1969 with the revolution and the change in the system under Gaddafi in 1969. But nonetheless, women have achieved many rights during the rule of Gaddafi compared to their previous situation, and also compared to the rest of the area and in the Arab world. So law number 10 relates to marriage, divorce. It has 73 articles. The women's rights are guaranteed, but there are nonetheless some articles which decrease the rights of women, above all if we're talking about repudiation. So if a woman repudiates their husband, this is a form of divorce almost. So according to this article, this does not give women the right to repudiate their husband. They are deprived of this right. The legislator has indeed reduced their rights. So when a woman asks for divorce, she has to leave the home, the family home, and she is on the streets, quite literally. This is fundamental to understand because it breaches the rights of women. And that law does not take into account the rights of disabled women, for example. And in the past, these women had some benefits from the state. Once a woman gets married, they no longer have them. They are taken away. So this clause has now been suspended. So now many women, many legal experts have carried out sit-ins to protest in order to recover this right for women, this support for women. And well, we see that women have their independent financial rights, regardless or separate from their husband, brother, or son. So the women have the right to sell and to have their own business. That is a right that they have. But nonetheless, other rights, for example, maternity, the right to confirm or have a child recognized as being then. A woman cannot do anything if the man is not present. The custody cannot be confirmed. A man can confirm, however, their paternity, but the mother does not have that possibility. It's very, very difficult for a woman, lots of court cases, to convince the judge that the child is the biological child and who their father is. So this is a big problem. If we talk about women who marry foreigners, they are always vulnerable, unprotected by the law, because they may have their rights guaranteed according to the civil code, but nonetheless, on many occasions, the women themselves do not know their rights, and they do not know how to exercise their rights when they decide to marry a foreigner. So I would say again that the law itself has offered progress, but at the same time we have seen steps in the backwards direction since the 17th of February revolution, because many laws have since been passed, including a law stating that women cannot take power, that women cannot hold positions of responsibility. And that was a harsh blow for women, because we work in the judiciary system and we are fighting to get into the presidency of the Supreme Court, and this is our objective, but the political will seems to be going in a different direction, in a rather old-fashioned way. Thank you very much.
Muchas gracias por la brevedad y...
Thank you for being concise and for providing us with that very interesting information. Now we'll go straight on to Magda Abidi, the chair of the Court of Grand Balia in Tunisia, to talk about equality for women, marriage, divorce, freedom of women. So she's going to explain her experience. Thank you very much. I would introduce myself. I'm a judge of the third instance. If we start off with the gender perspective, with regards personal status, I would like to talk about some of the background. The speaker, we don't think she has her microphone correctly switched on. Thank you very much. We're not talking about a biological difference, but rather a difference in social roles, according to which men and women have to live. And this is related to a reivindication of human rights in response to any inequality and, above all, sexism against women. There has been a trend towards the end of the 20th century in the United States, which spread to Europe, regarding the theory of genders, which differentiates between the two genders, masculine and feminine, not on the basis of biological differences, but rather their social roles. The role assigned to each sex, we could say. So the woman is limited to the role of mother and is kept away from the decision-making powers. And there's a feminist movement that has developed this theory, and this has led to several conventions which work to eliminate all kinds of discrimination against women. We have different conventions, as I said, and this includes the famous CEDAW convention, as we call it. In Tunisia, it's a Muslim country, so obviously we have suffered colonialism for some time now, for some time, and as a result, rights were not fully developed, and with regards to gender, women's rights were neglected and forgotten due to an incorrect interpretation of the religious rules and ancestral customs. When our independence arrived with activists, the activists came into power and they decided to recognize the rights of Tunisian women in the family context. So this led to the personal statute, as we call it, which was ratified on the 13th of August 1956. This is a very important date for Tunisian women. In fact, this date was chosen as the Day of Tunisian Women. And this really redesigned Tunisian family structure and introduced revolutionary reforms, the elimination of polygamy. That was in 1956 in Tunisia. Also, traditional marriage, the tribal marriages, also the patriarchal guardianship, which allowed a daughter to be married off without her consent. And the mother wasn't even involved in that decision. They didn't even need to consult the mother. And the reforms prohibited the marriage of children. There was an age below which women could not be married. In the past, it was 15 for women, 17 for men, and the legislator intervened because there was inequality between the rights of the two genders. So the same age was established for both, and that in the end is 18. That is the minimum age for marriage. In some cases, the court can give authorization for a woman below the age of 18 or a girl below the age of 18 to get married in special circumstances. These revolutionary reforms were implemented, and this led to the creation of modern family in Tunisia and gave an important role to women in Tunisia alongside men. Those were the main reforms, but there are more. For example, there are two situations, the situation of married women and single women. A married woman has the right to choose her husband. Well, consent must be formal and expressed before a representative of the civil state or a judiciary representative. And they have to, obviously before marrying, they have to at least be 18, as I mentioned. And in the last year, we have seen a change because Muslim women were not allowed to marry non-Muslim men in the past, but this requirement has been eliminated. Tunisian women can now choose their husband regardless of their religious beliefs. In the past, a certificate was necessary to demonstrate conversion to Islam. There are new rights as well related to divorce. I don't need to mention jurisprudence. The rights are constantly applied. There's no issue here. In the case of divorce, the woman can maintain custody of the children regardless of their nationality. And also she has the right to receive compensation or moral or material compensation, and this may include an income if she does not work, and she has the right to the custody of the children even if she remarries. The decision is taken by the judge, but always to benefit the child, in the best interest of the child. There are other laws which I haven't got time to talk about all of them, all of the rights, but I would like to talk about the right of the widow to inherit the assets of her husband, even if she is not Muslim. Those are the main elements in the law. Also, I forgot to mention that the repudiation has been eliminated. Divorce can only be declared via the courts, and that is the case since 1956. So we do not have repudiation as exists in other countries. The fact that women can choose how they wish to get married, the conditions of the marriage, whether they want to have a prenuptial agreement, and with a separation of property. So if a woman is divorced, she does not lose any of her legal rights. Let's say a woman can ask for divorce for any reason because she decides to, or out of mutual consent. I would also like to mention the main sentences which have been truly revolutionary, taking into the context. Recently, we saw a decision in a first instance court which allowed an individual to change sex. That was in 2017. That sentence is revolutionary because it was a girl, Lina was her name. She felt uncomfortable with her body. She did not feel like a woman. She went to Germany to undergo psychological treatment. She had an operation and afterwards went to the courts, the first instance court in Tunisia, to ask for the change of sex. The prosecutor's office opposed because until that decision, a change in sex was always denied. But now in jurisprudence we have a recognition of the right of this woman to change sex due to the sexual identity disorder, and she became a man and has now married a woman in Germany. So this is a really revolutionary sentence. There is another regarding the registering of babies' names. There used to be a law obliging or limiting the name for babies, and we have seen a judge ordering the civil servants to register a Berber name, or a Berber name, sorry. Another revolutionary sentence from the cantonal court in Tunisia. This is for a single woman to adopt a child. The law states that she has to be in an ideal situation to get married in order to be able to adopt, but the judge explained the reasons behind this decision. This was based on the fact that even though the woman was not married, she was capable of looking after a baby or a child. Those were the main sentences I want to mention. I've got more things written down, but I haven't got time, so I hope that, or we hope that during this legislation and with this jurisprudence, we will be able to see much more progress in the future, taking into account all of these issues to work for equality.
Muchas gracias. Pues bueno, con la esperanza puesta en la igualdad.
Okay, with all our hopes for equality in Tunisia, now we'll move to Italy. We're going to hear from Carla Marina. She comes from the Court of Appeal in Trieste for civil law and minors, and I would just like to explain that she's going to talk about the patriarchal system that is still an important part of the system or the structure in Italy. Thank you.
Much. I would like to thank you for inviting me to take part in this conference and discuss such delicate, difficult and sensitive issues. It is certainly a meaningful opportunity to dialogue with you. Over the past few decades, family laws have evolved everywhere, yet in different various forms, and it is therefore important to think on this change and the current situation. In my country, in Italy, following an early stage at the beginning of the past centuries, this path has started to come to life vigorously after the end of the Second World War. In that period, women were given the right to vote and to play a full and active role in the community, which led the Italian society to innovate and transform too very slowly. In 1946, the Italian Constitution was promulgated, together with the important acknowledgement of fundamental rights. This path brought up the relevance of a person as a human being. Thanks to the Constitution and its Article 29 and following section, family law became to center at the most living part of civil law. Nevertheless, it took more than 30 years for such principle already consecrated by the Constitution to be effectively implemented.
Would you like to?
Yes. Society historically changes slowly, and this change takes place through a progressive and continuous mutation in culture and legal role. Over the last 70 years in the Italian society changed not only the idea of family, but also the patriarchal model changed radically. Laws are meant to uphold social intersubjective rights by respecting the right of equality. This is particularly important in family law, where rights are more often violated. It will be useful to recall that the postmodern discrimination and inequalities were legitimate in Italy, to understand how many steps we have already taken. For a short time now, I remember only that in the past, the husband was the head of a household and one of whom everyone had to obey. Every family relationship was based on a power submission scheme. The husband was supposed to protect his wife. The wife had to take the husband's surname and was obliged to stay with him wherever he wanted to establish his residence. The address committed by women was a crime that justified a divorce. In the past, it was not allowed to marry a citizen belonging a different race. In the past, legitimate children were treated differently than illegitimate children. This mutation became undeniable after the 50s, and following booming economy. The forward in school and university of 1968 and the reinforcement of women's movements. During these years, we have had the divorce law and also the reform of family law, in particular this reform, in which the Constitution and its 99 were effectively implemented. This reform modernized the family in terms of equality, establishing rights and obligations of the spouses, and the head of the household disappeared. Both spouses were obliged in equal proportion to work together in order to organize their family life and agree upon their family residence. The community property was established. Illegitimate children became natural children, and also in 2012 there are any different from children born or not born in a family, only 5 years ago. In the last 10 years, we have other important laws that recognize both homosexual and heterosexual civil union and non-marital cohabitation. In the same years, 16, was introduced the quick divorce law, for which after 6 months of marital separation, it is possible to divorce in limited time and expenditure by going to the town hall, in case the couple has no children. In other cases, it's possible to opt for assisted negotiation, extrajudicial settlement. Now, what happened now? Family, woman, the traditional patriarchal family scheme is not completely broken yet, and neither are women completely emancipated. We still need to achieve a full equality. After a radical mutation, the political contest that took place in spring 2018, various draft laws toward the traditional model and are taken into consideration. In the name of alleged traditional family values, their draft laws were strongly restorative and provide for taking the idea of family and consequently to the status of women back in time, reviving the ancient form of family relationship. One of these upping measures is the so-called Pillow Bill, a law decree that, in case of separation of marriage with children, give prevalence to the right of ownership of the marital home. Children's custody is mathematically divided into equal periods for both parents, and there is no provision to maintenance allowance for children, whose expenses have to be covered by parent who has their custody. The bill recognized past parental alienation syndrome and recognized the possibility of no custody of minors by parents to whom said practice are attributed. Also provide for the regulation that impose a mediation against payment before proceeding with the marital separation. Our association write a document on request of the Minister of Justice, and this document have related in every branch of the national territory. In this year, in Italy, further bill proposals are still under evaluation, with provisions that question the right acquired by women a long time ago. For instance, they amend abortion, and also the question the family reform, and also the restore brothels for prostitution, and also they provide for the elimination of the civil union for gays and lesbians, and also for the law of the divorce. We are experiencing in Italy the effort to erase a freedom that has been laboriously achieved over time by women, and to resist the important social role of women, as already happened after the First World War. In closing, allow me to remember Simone de Beauvoir warning. Never forget that a political, economic, or religious crisis will be enough to cast doubt on women's rights. These rights will never be peaced. You'll have to stay vigilant your whole life. In light of this strong word and the current situation in Italy, all Italian women judged among them, must remember that the path taken by women has been marked not only by steps forward, but also by few steps backward before getting always back to the right way. Despite the difficulties and obstacles today, we therefore must go further and never stop. We must move forward together along the path we took, however hard it may be. We must keep on moving together with conviction and determination toward the goal, our goal. Thank you for attention.
Muchísimas gracias.
Well, thank you. Now, in our trip, we are getting to France, and there we have magistrate Ines Cherichi. The difficulties in France to accept this concept of gender as in Spain, another concern, this morbid concern, the fact that in disputes between parents and children, we accuse the mother, labeling her as a manipulator. Thank you to the organizers of this Congress. I will speak in French.
Mi madre es española, pero bueno, me parece importante también que se hable francés.
I think it's important to speak in French, too. The notion of gender is controversy in France. It's controversial. It contravenes the concept of the French Republic, which is the Declaration of Human Rights, mainly the equality between men and women. So we talk about gender difference, but the first time we talked about gender difference in the French code, that was in the criminal code in 2017 as an aggravating factor for a crime against a victim due to her gender identity, real or supposed. I think that gender concept is very important. It allows us to understand how legal categories are built and how the fact of classifying people allows us to legitimate or fight against gender inequalities. Gender exists in law, and law will make the difference depending on the gender. I think it is important to remember that from a historical point of view, the French Civil Code that comes from Napoleon is from 1804. It said that women had not civil capacities there. The legislator decided that women, as children, were incapable, and this had civil incapacity, and this had repercussions up to the present. The woman has to follow the man. She cannot manage her assets or her kids' assets if she becomes a widow. And in the French code, we talk very much about the concept of a good father of a family. This is a concept that was eliminated actually very recently. I will say that this women's civil incapacity in France was eliminated in 1938. In 1965, a woman can have a profession without the agreement of the husband. In 1970, this head of family concept is eliminated, and we talk about joint responsibility in the family. And importantly, in France, there is the transmission of the family name. I will explain that later, but traditionally, children had the surname of the parent, and only in 2002, the woman could transmit her surname. In 2009, very recently, we eliminated the concept of legitimate filiation. There were different categories between married and unmarried couples and their children. This gender perspective, in theory, in France, there should be a perfect equality. There should be no discriminations. Since 2009, after this change in the filiation concept, but we see that there are still inequalities. I guess you know many of them. So the legislator realizes about that, and we cannot enact laws, and the laws, the different laws remind us that equality is not real. There's a law of 2010 regarding specific violence against women, and also violence to children. This law created then in order to protect victims of violence within the family. We thought that in France, just reaffirming the concept of equality was important, but it is not. There is a law of 2014 designed to have actual equality between men and women, but we realized that equality was not real. There were 5 different realities. At work, violence against women, stereotypes, parity, and the non-payment of child support or alimonies. If legal categories are equivalent, let's enact a law that will say if a father doesn't pay the child support, a subsidy should be paid to that father. But if we see statistics, this is mainly women. So it is supposed that both men and women can request this subsidy, but when we see the breakdown, we see there the gender. Because if you don't pay the child support, 90% it is women who have the custody of the child, and they don't receive that child support from the father. So they should receive some subsidy from the state that will be removed if they have another partner. These women should declare to authorities if they have a new partner, someone who makes money for them, which is not equal treatment. And also regarding parental alienation. This meant new stereotypes and categories unforeseen by the law. The family judge, traditionally in France, sees women with the custody of the children, parents with the right to visit the children, and children who don't want to go to a father's home because there are accusations of violence or even sexual abuses. And in many occasions, the mother is accused of overprotecting their children. So what the mother and the child says has less credibility, because normally it's women who find in this situation, and victims very often are seen as guilty. So the Ministry of Justice, they have a plan to fight against violence against women. They have a plan for 2017 and 18. They published a document in the judge's intranet to be very careful about this parental alienation syndrome, because it can be proven from a medical point of view. And these categories is something we find when we analyze gender in different areas. The marital regimes in France, if there is no marital contract, the default regime is a joint marital property regime. So if you have a debt, you can recover that using your common goods. And as men professions are more risky, often it's women who finally have less revenues. If you have to make a compensatory payment, you take into account the consequences of the professional decisions taken by one of these spouses during the common life, so that regarding to use that for the education of children. So we see that there's still a separation of roles. To sum up, I'd like to mention a reform that took place in 2015. As in the past, women couldn't manage the assets. When one of the parents died, the judge authorized the surviving father or mother to sell assets or financial investments. And we saw there were many widows, women widows, that were imposed to request the authorization of a judge to close a bank account or to settle all these operations. I don't have time to keep on elaborating my ideas regarding civil registry with change of sex. There are many interesting things, but I will conclude by saying that, obviously, equality should also entail equal rights, but gender allows us to see that there are still inequalities. Gender is a tool to transform societies, both in France and Europe. And as this is an international congress, I think that the most interesting thing is to note that we are part of the Council of Europe, and French judges are very influenced by the jurisprudence of the European Court of Human Rights in Strasbourg, which applies a uniform jurisprudence on this, and this forces us to change our law. So this is a leverage for gender change, and it is interesting to see that it is European judges, because this European Court has a parity. These European judges produce the jurisprudence, forcing the states, among them France, to adapt their laws in order not to be condemned. Thank you.
Muchas gracias, Inés. Ahora llegamos a Alemania.
So now we'll go to Germany. Karin Bilder is a magistrate at the District Court of Hamburg, and one of the issues she wants to talk about is shared custody of children after separations, and I imagine she will talk about this briefly and concisely. Thank you very much.
Hello. I want first starting with thanking Gloria, because without her effort and her energy we wouldn't be here. And I want to thank personally our colleagues from the Arab countries and North Africa, because the insights they are giving in their legal systems are very, very inspiring, and it's good to hear that the pictures we get every day in the news are pictures on one side of your countries, and there are obviously many other aspects. Last but not least, I want to thank you, give a big thank you to the translators, because without them we couldn't understand each other. And I hope, as English isn't my English is not my native language, I try to talk very slowly and precise. So after thanking all around here, I want to apologize because I didn't bring a PowerPoint. But this is a decision. I'm going to talk about parental custody, the reform of family law in Germany, and we are in the process. So we are not that far, and if I had bring a PowerPoint, I would have only presented questions, and I was sure you didn't want to read any questions on a PowerPoint. So I'm going to talk about the ideas and the reforms we are in, changing our family law with the hope and the aim to modernize it. So, shared parenting, what is this? It's the situation for German children after their parents are in the process of separating parents, that they faced not losing one parent, which is a good thing, but they gaining two homes. One home at mom and one home at dad's, which means 1 week in one place with mom and the other week in a place with dad. So this is basically a very good idea, and for me it's one sign that why family law is really important and very much linked to the reality, social reality in our society, because now these shared or equal parenting is practiced. We don't have any valid statistics, but me being from Hamburg, it's a big city, I would say about 20% of the parents are already practicing it. So nevertheless, this is why I brought this topic to this conference. It's one of the topics hotly debated in public and in the news because of its different aspects for women and for the children. Well, we modernize our family law. We started, or no, not really started, family law for me, it's like always adapting. Society, families are changing, and the law tries to adapt. We have already for decades joint parental custody after divorce. Then we had a big new thing in '98 that was joint parental custody for unmarried couples. Then in 2013, next step, we had the right for the father, biological father, to apply for custody. This was one consequence of one of the ruling of the Council of Europe too. And now we heading towards the next big step, which means we are going to dismiss custody as a term and open up the door for parental responsibility. So these parental responsibility shows for me that language is very, very important, and it's a big discussion going on how we want to label or these new model of parenting. Because in Germany, unless different to the English language, we have no joint shared parenting. Sharing doesn't exist in German in a positive way. If you see it's the legal term in the English, shared parenting or equal parenting, you've got the vision of two parents being both very responsible, talking to each other and finding the best solution. So this provokes nice emotions, or could provoke nice emotions. In Germany, as we don't have these joint sharing, we split everything. We split a cake, we split housing, but we most definitely don't want to split children. So this is a point at the discussion we are at the moment. We're trying to find a term because we can't transfer the English term. We did this in different aspects. We use car sharing, the English term for this model. So because sharing is something, I don't know, probably it's not in our German nature that we can share something quite jointly. I don't know. It's really difficult. But well, we have to find a solution, and it won't be a solution that we can transfer an English expression because, of course, our legal language is German. Yes. Just to show the importance of language in the legal frame is that in the discussion, somehow the term, if you translate it directly into English, for these shared parenting, found his way, and it's really ugly and very technical. They call it the change model. So, and change model, you've got a vision of two houses, one child, little child with a rucksack hurrying between two houses. So we don't want that, and we're trying to get rid of this term because this term really provoked emotions in the public discussions. Well, this is one way of finding and making our law to be accepted, and well, we've got problems to adapt our family law because the idea of our current law is the residence model. Residence model meaning one cares and the other parent pays. So this doesn't work with shared parenting because the German family judge is only entitled, in case parents can't agree, to transfer decision rights. So if they can't agree on the residence, you transfer the right to decide to one parent. The parent, if you say it's good for the child, that it shares his time with both parents, the parent who wants that, who applied for that, will get the right. Well, okay, and then he's got the right, but how is he execute the right? Because when he says 1 week at my home, and the next week the child goes to the other parent, and the parent won't return the kid, you've got a problem, because we have no legal grounds of sending the police around and execute the family order to force the children back to the other house, which wouldn't be in the interests of the child anyway, so this is not possible. So we have to do this reform, and we have got already sentences from our Supreme Court trying to show the way how we can arrange that. But arranging the rights and the legal grounds to order it for the court is only one thing. The big issue in the political discussion is, and here comes the gender perspective, is about child maintenance. Because our women organizations say, well, this idea of two residences, two homes, is only for the fathers a very, very easy exit out of child maintenance. So, and well, family law has to cover all situations, but there is some truth to this, because I was talking to lawyers in Hamburg, and they said, yes, we've got fathers rushing in our office, telling us I want to apply for shared residence. I don't want to pay any more child maintenance to this woman. And when the lawyers ask him, okay, but how do you want to organize it? You're working full-time as a salesman, you know. The father takes his bag, walks out, and searching a lawyer who's going to court and filing this application for him. And furthermore, okay, I have to rush. Furthermore, every third single parent in Germany is female and supported by social aid. So if we make arrangements in child maintenance, it really can hit the financially weak single mother. Yes, 2 minutes, so I have to cut something off. And the main criticism against this model is that it's only a model for the rich. And this might be, I give you a short, quick example from Hamburg. A colleague of mine from Communicort separated from her tax lawyer husband. They both having 2 little boys under 10. So my colleague fell in love with a guy, a man who already had 2 little boys too. The tax lawyer fell in love with a woman, 3 kids, all of course separated. And then these 3 families managed to synchronize this residence model in a way that each couple had 1 week without kids to live their new love. So this was very practical. And you might ask, where comes the wish from? Where are we starting to watch the interests of the child? In this case, it wasn't necessary because I spent only 10 minutes in family court. But I had in my court cases in Hamburg, I had to do a hearing with a little 10-year-old boy. Doing the hearing in Germany is the judge doing the hearing of the child. His father was filing an application because he wanted the boy for 1 week. And the little one, he was looking at me and saying, well, 1 week there and 1 week here, this is only good for parents. And I said, okay, yes, that's a clever idea. So the reform, which is going to come to the end of the year, will have to contain new regulations on child maintenance, on custody, and this is a very in Western Europe countries a very current topic, because I know from other countries that they already did these remodeling of family law. Denmark has got a brand new law which came into action on the 1st of April. Norway is very ahead too, and in child maintenance and custody, we've got 2 other topics to deal with, which shows that the value towards children in our society are changing too. One big topic is, how do we acknowledge the will and the wish of the child? Until now, the German law knows only when it comes to the right to determine the name, that already 6-year-old children are asked what name they want to carry, and they can determine the name after completing their 14th year. But not in custody law, we haven't got any regulations. Norway is, even in material law, very ahead. They have got like levels of ages in which the will and the ideas of the child have to take into account. And another big topic is the obligation of mediation or counseling for the parents. If we give them more responsibility, which is a new focus of parental status in our society, at the same time, it needs some training or some measures to make sure that they're not rushing to family court with every quarrel they have, but they have to live up to this responsibility. And now I'm going to close, and as like Susanna Medina said, we judges carry a lot of responsibility in this area, because, at least in Germany, family law is judge law. We are obliged, and our task and job is to find for every family the adequate solution, with taking into account the wish of the child. And I really want to thank you to organize this conference, because I already got so many input from colleagues from other countries who got similar ideas on already regulations. This is very fruitful for me. Thank you very much.
Muchas gracias, Karen. Y bueno, acabamos.
Thank you, Karin. We shall finish our trip in Holland with Carina de Koning from Amsterdam. She will talk to us about what needs to be dealt with regarding issues affecting lesbians and gays, and I shall give her the floor so she can tell us about that.
Hey friends, I thank you very much. I thank Gloria also and the whole organization here in Spain to have this nice conference and to be able to talk with each other. Apart from all due concern for the position of women and children all over the world, I would like to focus on the position of a minority group that, in my opinion, needs our protection too. After all, during this conference, we are focusing on justice with gender perspective. And I think it's good to realize that gender does not always mean heterosexual men or women. There is a larger variety. I do realize this is a sensitive subject, and we will see in a moment, and we know, a broad division exists between parts of the world where other attraction than heterosexual is not allowed or discussed. Also, within our region. We have a very diverse region, therefore very interesting. So I do hope you will appreciate it, that we will discuss this subject in this distinguished group of judges and lawyers. First, I just give the definitions. We are talking about LGBTI. This is lesbian, gay, bisexual, transgender, where I need to stress that a transgender is a person who doesn't identify with the sex they are presumably born with. Presumably born with. Because the next category is intersexual, which is also rather new to me, but worldwide it's not so new. But there are children born, and there's not only one in a million, but much more, where the physical sex characteristics partly fit male and partly fit female bodies. If we focus on lesbian, gay, and bisexual, I would like to talk about the problems they encounter. There are countries where any of this homosexual behavior is forbidden by law. Another problem they encounter is discrimination, violence in public, and stigma. Another problem may be the possibility to marry or to adopt children. I will address these problems one by one. Forbidden by law, all over the world, there are 72 different countries that forbid, as a criminal offense, same-gender sex. Of these 72 countries, there are 45 countries in which relationships between women are an offense. In others, relationships between, I already said that. These countries are situated from the Middle East to the Far East, Asia, and Africa. Religion or culture is a predominant motivation in those countries, but we will see it has been the same in Europe as well. Penalties vary from a fine, imprisonment for years, and even death penalty. It's not only Muslim countries, but it's also Protestant religion that strongly opposes against homosexual behavior. On this slide, I briefly show the history of decriminalization of homosexual conduct. Homosexual conduct was forbidden in Europe, as I just said, since the 13th century. But then, with the French Revolution and the Enlightenment in Europe, homosexuality was seen as an illness, and therefore homosexual people were not to blame. And that is why homosexuality was decriminalized in France, the Benelux, Italy, Spain, and Portugal. As you may notice, those are the more Catholic, have more Catholic religion. Then after that, but 100 years later, homosexuality gradually decriminalized. Also, in the Protestant countries in Europe, these 100 years later, homosexual behavior was decriminalized. Remember, I said that homosexuality was seen as an illness and therefore decriminalized. Who can help it if he's ill, or she? But then the psychiatrists had a new insight, a new development in psychiatry, that in 1973, homosexuality was no longer a mental disease. And that was according to the DSM. I don't know whether you're familiar with the DSM, but it's the psychiatric scale of illnesses. And then in 1990, homosexuality was no longer a mental disease. No longer a mental disease according to the World Health Organization. So that was, those two developments are worldwide. And it's difficult to esteem, but it is thought by questionnaires that about 5 to 10% of all people are homosexual, also within this room. And we do have to take into account what that means for those people. This percentage is estimated by questionnaire, but a questionnaire is always the difficulty, has always the difficulty that you do not know if they give true answers or not. But they think it would rather go to 10% than 5%. This is, I will show a map now with the division of criminalization of homosexual behavior. Dark blue means there's an explicit legal protection of homosexuality. Then the scale to blue and light blue are the countries where an interpretation of the law, so judges' right, provides for protection of homosexual people. The sand-colored countries do not forbid homosexuality, neither give a protection. From yellow to brown, penalties in homosexual conduct are from fine to imprisonment, and the dark brown countries still have death penalty on homosexual behavior. I have to be a bit quicker than I thought, so the next slide I just show you, and you all know that discrimination and violence in public and stigma of homosexual people is very, very often happening. Then marriage. There's a development where the recognition of gay marriage is expanding enormously. Well, I actually am proud that the Netherlands already had a law in 2001 where gay marriages were allowed. Then many, many countries followed, and it's easier to show on a map where gay marriage is allowed. You see the same type of division where actually in Africa, South Africa is an exception, and also Israel in the Middle East is an exception. Then briefly on adoption. Adoption by married gay people or people with a legal registration which is similar by law as marriage, then adoption is also possible, because we cannot discriminate between heterosexual couples and same-sex couples or marriages. So with the start of the gay marriage, we also have the gay adoption. Also stepchild adoption, that's where it began with, is a normal thing now in many, many countries. And I will again show you a slide of the division of adoption in over the world, adoption by LGBT couples, same-sex couples. Then I would like to just show what I found, and I must say this is especially from American studies. The homosexuality, they say the homosexuality is a natural and normal human sexuality. Sexual orientation is not a choice. Gay people form stable and committed relationships that are essentially equivalent to the relationships of heterosexuals. Same-sex parents are no less capable than opposite-sex parents to raise children. No civilization or viable social order depends on restricting marriages to heterosexuals, and the children of same-sex couples fare just as well or even better than children of opposite-sex couples. I've been wondering, why would that be? It could be heterosexual couples can get children just like that. Homosexual couples have to make a very, very deliberate choice to want to be a parent, of course, for obvious reasons. And then there's a new scientific insight, and that is that we do not really have males and females. Yes, we do have the alpha type man, you know, those. And we do have the Barbie-like girls. Those we have as well. But in between, there will be much more if you look into it. And that is a new development in science on this. Well, very briefly, I have to, less than 0 minutes. I also want to say that transgender problems are less difficult over the world than homosexual problems, because many more countries, like you just said from Tunisia, many more couples accept that somebody does not feel like the gender the person is registered with. And if this person goes this far to have an operation and everything and hormones, then many more countries are okay with the change of the registration. In India, there's a very, very old Haira way of looking at, before we called the people the hermaphrodites, and they are mythical people, and they do always accept that some people are somewhere in between male and female, and they are protected for that, but not always. I think, the intersexual, I gave a very short introduction. I would just like to say that judges are have always been the ones that change, that give change to the whole society in this perspects. So there are many landmark decisions all over the world made by judges, and after that, the law changed. And it's a recent development up until April 1st, 2019, where the Lebanese military prosecutors acquitted 4 military personnel that affirms homosexuality is not a crime. Thank you very much for listening.
Muchas gracias y gracias. Ya sé que a veces.
Thank you very much. I know that it's often difficult because what we say here is very interesting. It's very difficult for me to cut you off, so excuse me for doing this. There are the round tables. There's another one remaining. I've been told that regarding question time, if you want to make any question, we can accept 2. I see there is. Hello, good afternoon. I was missing here that you didn't mention at all children of women in regime of custody who are victims of gender violence. What happens to them? Do we really have to grant a joint custody for the good of the children to some men who are attackers, who are aggressors, who are offenders? These children may have seen those aggressions. So it's a general question for you all. If you can elaborate a little bit more on this issue, would you like to respond to this question?
The problem how to deal with violent fathers and traumatized children is in German law very not actual, but we take it into account. And as we've got the family law already giving joint custody, it's more a question of withdrawing the custody and giving it to the mother than giving custody to a father who's violent. So this is well. The equal parenting is only fit or will be implemented if it's for the best interest of the child. So, and what is the best interest of the child is always question of finding out for the judge. But of course, we've got rulings and sentences, and I can agree to Karina that we courts, it's the job of the courts to set the standards, because the law gives only the ideas, and violent fathers, well, it's a high level to withdraw custody in German law, but if there's repeated violence, and especially if the father doesn't work on himself and won't go to therapy, and furthermore has got no insight in his own behavior, this is a reason why there will be a prohibition of contact, and even if the parents can't communicate, this is the big issue in Germany. We always have to watch, can parents communicate? Because if they're not communicate, this always is a problem for it's a danger for the child and for the development, psychological development for the child. We take this into account, of course. So.
Sí, aquí arriba teníamos la palabra.
Es que también me la habían pedido aquí abajo, entonces tengo para una más.
Pues yo la había pedido primero.
Bueno, vale, pues.
Muchas gracias. Bueno, me llamo Lourdes Pastor y estoy aquí representando a la Plataforma Andaluza de Apoyo al Lobby Europeo de Mujeres. En primer lugar, agradecer que hayan hecho esta jornada tan necesaria, porque contra una justicia patriarcal yo creo que lo que se tiene que encontrar es el feminismo de frente y una justicia organizada por mujeres feministas con conciencia. Siguiendo con la compañera Elena y contestando, bueno...
Following what Elena said, the lady from France and Germany, after listening to them regarding custodies and children's support, this is not only a matter of violent fathers and traumatized children, as the German colleague said. It is about why we women have to face alone the fathers of our children, and also face the system to claim that they pay the children's support that they have to pay. Because actually it is the state that has to be behind the fathers to pay that children's support. With this, we would avoid many cases of violence and murders to women who were not victims of violence before being separated. They become a victim of violence after the separation. It is a problem we have in this country. We shouldn't grant custody to abusing fathers. We have to assess when to grant a joint custody or not. Many fathers don't pay children's support, and they request joint custody. And in many occasions, they want to act as a father once they have divorced or separated. Why they want to be a father once they have separated and not when they were in a relationship, in a marriage? You, women judges, have much power. It's a pleasure to see so many of you. Prostitution and surrogate mothers should also be considered as a form of violence in all countries in the world. Thank you very much. Someone wants to respond? A short remark. Ines? No? Okay. So, thank you all. Now there's a coffee break, sorry. During that coffee break, you can talk to each other as we did during lunch. Thank you very much. Gonzalo, now you have some work to do. Thank you very much.